Okay, hello and welcome to our November webinar. This month we're going to be having a look at some recent key employment cases that have been hitting certainly the employment headlines, and also some legislative changes and some sort of things that may be forthcoming, just to help you plan and stay ahead of the curve. For those who don't know me, I'm Emma O'Connor. I'm a legal director in the employment team, and I also head up our HR training academy. What's really great is that this morning we're joined by our newest member of the team, and that is Megan Mangarano. And Meg is our trainee. So although Meg is new to the team, she's not new to Boys Turner, are you, Megan?
No, that's right, Emma. So hi, everyone. I've been with Boys Turner now for just over 3 years. And I've been part of the clinical negligence team and the wills, trust and probate team in my time. And now, as Emma said, I've just joined the employment team in my first seat of my training contract. So yes, thank you so much for having me join you today, Emma.
Brilliant. Thank you so much as well. So here are our contact details if you want to get in touch with us, if you've got any queries or questions, or want to hear more about the employment team and how we can help you. So for those who don't know Boys Turner, we're a commercial law firm based in the Thames Valley. As I said, I'm a legal director in the employment team. So we offer HR support, litigation, advice, business immigration, and also training as well. So if you want to hear more about compliance training, be that training on data protection, bribery and corruption, how to manage investigations, how to manage those complicated SDSs with our IR35 compliance, then do get in touch. There are some recent examples of training that we have done for clients. So if that's of any interest to you and to your business, then do get in touch. Just a bit of housekeeping. We are live, so again, please bear with us and the technology. But if you would like to post any questions, then please do so within the chat facility. If we can't answer queries during the session, we're going to talk for about sort of 45 minutes or so. But if you do want to post any questions, then we will do our utmost to come back to you after the session. And as always, we're providing an overview. So if there's anything that you want to hear more about, if there's anything that impacts on your business, then again, please do get in touch or take your own specific independent advice. So what are we going to be talking about in the next sort of 45 minutes or so? Well, first, we're going to be looking at the continuing saga of worker, self-employed or employee, take your pick. So we're going to be talking about recent cases on that. Then we're going to be looking at the national minimum wage, and in particular, the sort of thorny issue of deductions. So what you can and cannot deduct from your employee salary and how that might potentially fall foul of the national minimum wage. An issue that I've been talking about a lot and ran a recent HR manager workshop session on is flexible working. So we'll be looking at some recent cases on that, and also how those straddle into the area of discrimination, as well as talking about discrimination more generally. And again, we're going to be focusing on a recent case that's come up, which looked at the menopause. And again, regular attendees will know that's a topic that I've been talking and writing about recently. We're also going to be having a look at how legislation is going to be impacting on those areas as well. So we'll be talking about that as we progress. So the first case, the first case involves Stuart Delivery and Mr. Augustine. Now this, as I said, is this issue of whether, to be or not to be an employee. So Meg, can you take us through the facts of this first case, please?
Of course. So Mr. Augustine worked for Stuart Delivery Limited as a courier. While he was working for them, he could accept jobs on an ad hoc basis or sign up to work at particular times, which were referred to as slots. And with these slots, there were financial incentives in order to sign up to them. There was a system for booking the slots, and it allowed a courier, if they couldn't fulfill that certain slot which they booked, to offer it to other couriers on the platform. The interesting thing was that if no one else agreed to that slot, then the original courier would remain liable and any negative impacts would fall to them, so they could face a penalty. When the relationship ended between Mr. Augustine and Stuart Delivery, Mr. Augustine claimed he was a worker and he was therefore entitled to protections which are not available to those who are self-employed. So things like the right not to have unauthorised deductions made from his pay and the protections under the working time regulations. Stuart Delivery, however, argued that he was not a worker, and this was on the basis that he wasn't obliged to perform the services personally, as he could substitute the work out if he was no longer able or willing to perform in one of these slots, as I've said. So yes, I'll pass back to you, Emma.
No, thank you. And I think really this case sort of focuses on two key issues. And many of you will probably have heard myself, my colleagues talking about this obligation of mutuality and what does that mean? Well, in an employment relationship where you have this contract of service, your employer will offer you work, and as its employee, you will accept that work. And your employer will control how you work, where you work, and what you do. So there'll be policies and rules and procedures, etc. But where you have this self-employed relationship, so you have this contract for services, there is greater freedom on the part of both the client and the self-employed individual. So, for example, the client may offer work, and because the self-employed individual is in business, as we say, in their own account, so they're taking their own financial risk, they can decide if they want to accept that work as well. So there is not that mutuality of obligation. And then we have the second issue, which is really focusing on what we call the right of substitution. And many of you who've got agreements with contractors or freelancers will have this right drafted in there. And what that essentially means is when you are an employee, you have to do the work yourself. So, you can't send a substitute or anybody else to do that work. You are employed to perform under your contract of service to perform that role, and you have to do it. Whereas we often see in those self-employed contracts, in those relationships, that there is that degree of flexibility. So the client just wants the job done. And in many respects, they don't really care who does that job, but they often do put restrictions on that. And when you do have those restrictions, that's when often we can see a bit of conflict. So, well, how flexible is this right of substitution? And is it in fact a way of the client, in fact, controlling who does the work? So it looks more like that contract of service rather than a contract for services. Now we have this sort of third category, don't we? This worker, and this is what we've seen lots in the recent cases involving, Pimlico plumbers, lots of courier companies, and Uber, etc. And here we have this sort of hybrid way of working where there is often a degree of both. So there's often a degree of obligation. So, you're obligated to take that work, but then you obviously see a bit of element of flexibility as well in the individual deciding when or how they work. So that's what we're sort of seeing in the case law at the moment, is this sort of conflict between our traditional view of what an employee is and our traditional view of what a self-employed worker might look like. And that's where we're seeing this conflict, because we're seeing the way that people are working is not necessarily in tune with our sort of, our case law. So we're seeing this sort of conflict here. So Meg, on that sort of background, what did the courts find in this case?
Yes, so interestingly, the tribunal and the Employment Appeal Tribunal both agreed that Mr. Augustine was a worker, so falling into that third category you were speaking of, Emma. And they found that Mr. Augustine's ability to offer a slot to a substitute courier didn't actually impact on that requirement for him to provide that personal service. Stuart Delivery did appeal to the Court of Appeal, so it had made its way through the courts, but that appeal was also dismissed. So the Court of Appeal there said that the key issue was whether the claimant undertook to perform personally the work and services for Stuart Delivery. And the conditional right to substitute, it may or may not be inconsistent with the personal service, but that really depends on the conditions that attach to the exercise of the right. So it really is depending on the circumstances and how we work. It's very much on that basis.
Absolutely. And I think, again, although we're sort of taking the case law forward, we're still in this situation where, one size does not fit all. And because you might have one element of, personal service does not mean that you're automatically sort of pigeonholed into this, you are an employee. So really, we're looking at, the facts. All of these cases are very fact specific. But I think there are some takeaways from this. And I think the most important thing is to really understand how your workforce are working. So let's look at what we're doing. And I think, the IR35 has certainly encouraged more of this auditing to be done because, we've obviously got obligations there as well. But when we're looking at this pure sort of status issue, how are your people working? How long have they worked under particular, relationships? Certainly the longer that somebody has been with you, then, the more there is a greater risk that they may become, part of the furniture. So it's really looking at the reality. And again, you can have the best drafted agreement in the world, which has, all these rights of substitution, but it's how that relationship works in practice. So really, focusing there on how your workforce is working in practice. But again, it's going to be a question of fact and degree in each case. Now, the next case is quite interesting. I just want to talk about, just whilst we're talking there, we're going to be talking about the national minimum wage in that case. And I just wanted there just to sort of focus on, we do have rate increases. Obviously, we have the rate increase in October, and then we know that we have the rate increase as well that's going to happen in April as well. So again, making sure that we've got those rates, making sure that we're paying the correct people the correct rates. So making sure we've got that connection there with our payroll as well. One of the criticisms actually of the national minimum wage, and certainly what we're going to look at in our next case, is around the deduction point. So when can employers lawfully make deductions from wages for things like uniforms, subscriptions, etc., and when that might fall foul of the individual not actually earning what they should be under the national minimum wage. And often this can be criticised as being very difficult for employers. Now, this next case is quite interesting, and those eagle-eyed amongst you will see that the claimant in this case is also a Mr. Augustine, potentially like buses. We have tried to find out if they are the same. They certainly share the same initial. So if anybody does know if they are the same Mr. Augustine, do let us know. But yes, Mr. Augustine and Data Cars Limited. Meg, what are some of the issues in this case?
Yes, so either the same or a different to Mr. Augustine was employed as a driver by a taxi firm called Data Cars. He successfully argued in a previous hearing that he was a worker and therefore he was entitled to the national minimum wage. So the issue and what the claim really concerned was some of the deductions that Data Cars had made to his pay. So Mr. Augustine, in arguing this claim, told the Employment Tribunal that he was required to pay certain costs. So that included a circuit fee of £148 a week, plus £12 for renting equipment. And that all covered things in order to have the booking system in his car and for work to be allocated to him. He also rented a vehicle and had to have a certain level of insurance for transport for London. So that cost just over £2,000. And there were also costs to keep his vehicle clean and fuel costs, which he had to incur while working for the firm.
And I think, that may be typical in other sort of sectors as well, particularly leisure and hospitality. We see individuals having to, pay for uniforms, etc. And this is one where we have this disconnect between what the Employment Tribunal found and what the Employment Appeal Tribunal found. And whilst the Employment Tribunal was happy with some of the deductions that had been made by the employer, the EAT's approach to this was very much focusing on what deductions are integral to that work. So what is it that the employer has to deduct? What is in connection with the employment? And I think that's a really important sort of takeaway from this case. So we're really looking at those, what is in connection with the employment. So if we take that as our takeaway from this case, Meg, what was it that, what was, in connection with the employment in this particular case?
Yes, Emma. So whereas the tribunal had found that certain costs, in particular costs that Mr. Augustine had paid in getting a uniform, were not required, it was an optional extra. When the case went to the Employment Appeal Tribunal, they said that that was wrong. And essentially, like you said, it focused on being in connection to, and that was something that was in connection to Mr. Augustine doing his service for the firm. So they found, especially as he was a designated gold driver, that he was required to wear that uniform, and so the expense was directly related or in connection with the employment.
Absolutely. So I think a useful reminder there, again, go back, check, audit what payments are coming in and out, and whether they are in connection with the employment. And again, it's going to be a question of fact and degree in each case. So useful reminder there. The next issue we're going to look at is one that certainly we've been noticing a rise in the amount of queries and questions that we've had in from clients. And this is on the issue of individual flexible working requests. Now, the two cases that we're going to talk about here are both concerning flexible working, but in two sort of separate ways. The first one is looking at where you have that individual request. So an individual makes a request to vary their hours. And the second case there involving the NHS Trust is where the employer was looking to introduce a new flexible working or shift pattern, a different shift pattern. So it's really showing how, and I know lots of employers are looking at how they want to work at the moment, whether they want to adopt some sort of hybrid working patterns. I think it's really important to focus on not just the impact on an individual basis, so those individuals making those individual flexible working requests, but also the impact when businesses look to make changes more generally across the board. So the first case involving Mrs. Thompson is probably the sort of typical case that we would see as lawyers. And this is one where an individual was working. So she was working Monday to Friday, 9 a.m. to 6 p.m. And following a return from maternity leave, she made a flexible working request to her employer, and she wished to change her hours to working a 4-day week, but being allowed to leave work at 5 o'clock on those days to allow her to collect her child from nursery. Now, the employer rejected that request. They also rejected it on appeal as well. So where you've got that situation, Meg, of an employer refusing that individual request, what are some of those consequences, particularly the consequences that this employer found?
Yes, so in this case, and what can arise in many cases on these types of facts, is claims for indirect sex discrimination, and particularly here it was on the basis that the effect of her former employer's requirement to work the hours that they set, the full time 9 a.m. to 6 p.m. Monday to Friday, placed women as a group with children at a substantial disadvantage than men with children.
Yeah, and although employers have this ability under the flexible working requests regulations to reject a claim, and we have those 8 statutory grounds there, they still have to be very mindful that not only do they have to follow the flexible working requests, but also those consequences more generally, particularly in this area of indirect discrimination. And this is where your requirement or your policy or your practice places one group at a disadvantage because of a protected characteristic when compared to others. Now, unlike direct discrimination, in indirect discrimination, employers can offer what we call an objective justification. So basically, we are trying to, by introducing this policy or this criteria, it's for a legitimate business reason. And that reason is objective, and really that trumps any disadvantage that may be caused to you or to you because of your protected characteristic. And we don't have another non-discriminatory way of achieving this legitimate aim. So, for example, in the Thompson case, the employer sought to argue that one of the reasons for rejecting her claim was that clients preferred to deal with one estate agent. They wouldn't take very kindly to dealing with lots of different people. And that was one of the grounds that the employer said. But actually, the Employment Tribunal, now this is a first instance decision, so it hasn't been appealed. But the tribunal actually found in favour of Mrs. Thompson, and they said that, you know, despite the encouraging signs that there's been a sort of societal shift in childcare responsibilities, the burden does fall more heavily on mothers than fathers. And they said that that requirement to make her work Monday to Friday 9 to 6 placed her and other women at a disadvantage, and that those reasons that were given by the employer were insufficient to justify that requirement. So the employer in that case failed. I think what's really important is that not only did they lose an employee because she resigned, but also that the compensation that was awarded was £180,000, which is a lot of money. And that covered loss of earnings, pension contributions, injury to feelings and interests. So when we think about discrimination cases, we need to think about obviously the impact on the business, on the individual, the costs and the time to the business, but also compensation. So, you know, it's one that we do need to think about. So we've got that example there of where we have the individual making that individual flexible working request. Next, we're going to look at another case, which Meg's going to talk us through, which focuses now on the employer adopting a different policy. So what happened in the Dobson case, Meg?
Yes, as I say, Emma, this is where it kind of switches and it's the employer. So this one is a very interesting case. Mrs. Dobson was employed as a community nurse since 2004, and she has 3 children, 2 of whom are disabled. Following the birth of her first child, it was agreed that she would work 15 hours per week over 2 fixed days, and that was to provide for her childcare activities. And this continued for a number of years until 2016, when her employer introduced this new flexible working policy. As she was a community nurse, the policy was that community nurses were required to work more flexibly, which included some weekends. And as a result, Miss Dobson was asked to work the occasional weekend, and it was no more than once a month. Miss Dobson, because of the responsibilities that she had, rejected these changes, and she raised a grievance. There were a number of meetings with Miss Dobson, and it was actually suggested that she was dismissed and offered new terms to work on those additional flexible days. However, Miss Dobson refused this offer, and she was dismissed on notice. And again, this is another case where the claim was indirect sex discrimination.
Also, another interesting point there, we've got this point about fire and rehire, which those of you who subscribe to our online updates will know that was our focus this week. So again, check out our articles. If you want to sign up, then let me go. So again, fire and rehire, another issue there for employers. But I think what's really interesting about this case is it really goes to this point about justification. So in this case, the Employment Tribunal actually accepted what the employer was saying. So what the employer said was, well, look, we've got a group of 8 community nurses here, and actually it's only Mrs. Dobson that can't comply with that requirement. So in that group, they had 8 women and 1 man. And basically they said, you know, Miss Dobson is the only person within that group who can't comply. So she can't really show that there is a disadvantage to women, because she is the only person who can't comply. And also they said, well, look, if we're wrong in that, we accept the justification that the trust is giving, that they're trying to improve efficiency, they're trying to improve patient care. So we think even if we're wrong on the pool bit, actually we accept that it's a proportionate means of achieving a legitimate aim. Fast forward to the Employment Tribunal, and they say, no, actually, Employment Tribunal, you've got that pooling wrong. It's not enough just to look at the group of 8 or 9 individuals. What you really need to do is you need to look at all community nurses across the whole trust who are impacted by this policy. And if you looked at that, then the answer may be very different. And secondly, the Employment Appeal Tribunal said, look, again, this idea about, yes, there are societal changes, but there is still this childcare disparity, recognising again that the burden of childcare, primarily falls on women. So again, yes, there are some changes, which is fantastic, but again, tribunals have to be aware of childcare disparity. So again, when the Employment Appeal Tribunal looked at this, they said, no, tribunal, you need to go back and you need to look at that pool differently. And also you need to look at the wider impact of this policy criteria of practice. So if we look at flexible working requests, and again, I think it's one area where I think businesses need to sort of focus and certainly have them think about manager training and HR updates. But my advice to you would be the 3 C's. I think, firstly, when we think about communication, and this really works when you have those high trust relationships between employees and their managers or employees and HR. And really what we're talking about here is managers or HR talking to your people. So sort of anticipating where those issues might come up. So talk to your individuals who might be leaving to have a period of family leave. Talk to individuals that perhaps might be thinking about retirement. We're not asking for anything to be set in stone, but at least you're having those discussions, so that if a flexible working request is made, then it's not coming as a shock. So have those high trust relationships and have those conversations about what people might be thinking. And, consider those requests. And we've seen in the 2 cases that actually employers, you can't just, decide, well, we think it's this reason, we think it's that reason. We've got to be able to justify it. And also be creative, think outside the box. You may not be able to offer the employee what they're asking for, but can you do something in a different way? And I think, if you don't get creative, then other employers will. And, we've been talking a lot about, the Great Resignation and employees being in flux and not really sure, if the grass is perhaps greener working for another employer. So we really need to kind of get into this mindset that actually, flexible working and people wanting to work in a different way shouldn't be seen as a hindrance, but actually a positive step forward to make our workplaces more inclusive and more diverse. So a really good opportunity to really focus on our plans, take a step back, but also think about how we can perhaps flex our ideas and flex our plans maybe in 6, 12 or 18 months, because certainly, plans will change as we move forward. Another case which actually touches on flexible working as well, but actually was quite groundbreaking in the sense that it's looking at this area of associative discrimination. So Meg, what is associative discrimination?
Yes, so as we know, discrimination cases relate to actual or perceived protected characteristics of an individual. So that's someone being discriminated, for instance, because of their age or their race. However, we have seen an extension to that, and that's to include where a person's discriminated, not because of their own protected characteristic, but because of a protected characteristic of someone they're associated with or close to, so say a partner or a spouse, child. So we will remember a case where there was a legal secretary who made a flexible working request to care for her disabled son. And when this was refused, she was successful in arguing that the decision just saying no was disability discrimination by way of association. Then when we move to this case here follows, this is where nationwide we're requiring senior managers to be fully office-based, which in the times now seems a bit mad, I suppose, to most of us. However, and some people would say quite rightly, the claimant objected to this, but she objected on the basis that she was a primary carer for her disabled mother. So the claimant herself was not disabled. So this is what we're saying by discrimination by association or associative discrimination. So she was not disabled, but someone close to her was. And the claimant was employed under a home working contract. So she worked mostly from home. That was her principal place of work, but attended the office 2 to 3 times a week. She argued that she couldn't comply with this new policy to work fully office-based, and that the policy itself was indirect discrimination by way of association.
I think what this case again shows, and again, you know, those of you who've listened to webinars before or you've attended sort of training sessions that I've run, it's really about this point about know your people and know your teams. And, you know, and again, sort of looking at where those issues might arise if you're looking at introducing policies and really understanding and trying to balance those needs of the individual against the needs of the business. And I think having that sort of, you know, adopting that balancing approach rather than sort of, you know, steamrolling through with plans. So, you know your people, know your teams. And when you're thinking about, you know, flexible working, hybrid working, you know, really look at how that may impact on your people. And remembering that not all your people are the same. You know, people have been working in lots of different ways, you know, been impacted in lots of different ways over the last sort of 20 months. So again, you know, one size may not fit all. So do, you know, be aware of the risks. And we've seen lots of talk, haven't we, as well, about the future of flexible working, Meg. And we know that we've got some government consultation there, which closes on the 1st of December. And we've put up on the slide the sort of the 5 areas that the consultation is going to be looking at. And I would encourage people to go and, you know, look at consultation, you know, whatever it might be, and, you know, make your views known, because, you know, these things will impact upon your future plans. So you've put up there, obviously, the sort of the 5 key areas that the consultation is going to be looking at. What would you say would be some of the key issues that employers might want to think about when they look at the consultation?
Yeah, so I think out of the 5 that are on the screen there, we really focus on the 2 first bullet points, and particularly the first one in making the right to request flexible working a day 1 right. So as some of us may know, currently employees need to have worked 26 weeks in order to make a flexible working request. So the proposal in the consultation and what the government are wanting people's views on, or whether this service requirement should be taken away and that the right to request flexible working is available at the outset of a person's employment. This, of course, will have a massive effect. It will bring so many more employees into the scope of the legislation. And it also shows the government's aim for employers to really start, and encouraging employers to really start thinking early on in a person's employment about the options for flexible working. And, you know, that goes into job design and the recruitment process itself as early as that. What it has said, though, in this consultation is that it's not the right time to ask employers to include whether flexible working is an option in their job adverts just yet. So we're not quite to that point. But as Emma was saying, in the great resignation that we're facing at the moment, with people looking to change jobs, what is attractive, and statistics show it can be more attractive than the pay, is flexible working. It is really one of these very, very sought after qualities of work now. And those looking to switch jobs, you know, it will be interesting to see what the effect of making all work default flexible, to see whether that switching jobs and what we're seeing at the moment with trouble retaining people will continue, and what effect that will have. The other interesting thing will be, as I said, the second bullet point on the slide there. So that's the 8 statutory grounds for refusal. And that's really whether post-pandemic we can say that these remain as valid as they were pre-pandemic, and whether they're truly representative of legitimate business reasons to refuse a request. So Emma, those are the key ones, but yeah, all of them have merit, and it'll be interesting to see what happens.
And I think that point about the statutory grounds is an interesting one, because, you know, looking at the grounds now, you know, it's things like, you know, inability to, you know, divide work, inability to provide, you know, client service, additional cost. And I think, you know, a lot of those reasons now may look a little redundant, because, you know, people have been working remotely or flexibly, you know, because we sort of had to. So actually, you know, now, are they really relevant? Because if an employer says, well, you're not going to be able to service a client, well, you know, depending on your sector, where you work, how you work, etc., and obviously all businesses sectors are different, but, you know, that argument is not perhaps going to cut it. Whereas actually what employers are looking at now in terms of, you know, where we're working and how we're working, looking at those concepts of, you know, creativity and collaboration, mentoring, developing our junior staff, and, you know, teamwork, all, you know, absolutely valid. But, you know, they're kind of sort of, you know, floating around. How can you put, you know, a value on them? So it's going to be quite interesting to see whether these sort of new, you know, issues that have come up, and perhaps, you know, challenges to remote and hybrid working, how they might fall within the statutory grounds, and how employers are going to be able to justify being able to use them. So I think lots of issues there, but do go and have a look at the consultation, as I said, and, you know, as well as sort of the future of flexible work, we've got some other areas there as well. So again, you know, looking at carers leave. So again, some issues there. Again, you know, we're looking at when parliamentary time allows. So, you know, we're not potentially looking at anything that may happen imminently. But I think, you know, when we're seeing, you know, other employers looking at sort of, you know, policies on carers leave, is it something that employers should be looking at now as one of those sort of, you know, value added benefits that they can offer their people, for those who are looking to create more of a work-life balance? So, you know your people, know your teams, who might this benefit for, and is it something that we want to do as a business? And one of those other issues that we've been looking at is around the menopause. And again, regular listeners will know in September, I was joined by the fabulous Dean Murray, CEO of Menopause Experts, to really focus on, you know, what the menopause means for your people, for your employees, but also what employers need to know and how we can support, you know, our women at work. And this case looks at the menopause, but in the field of disability discrimination. And what we've seen over recent years is an increase in the number of employment tribunal cases coming through, which have cited menopause as one of the reasons for either less favourable treatment or having to leave their job. And the case involving Rooney here, Mrs. Rooney, is no different. So Meg, what were some of the issues in this case?
Yes, so I was actually a participant. I watched the menopause webinar that Emma did, and it was very, very enlightening. So I do urge everyone to look at our YouTube channel for that. But yes, the Rooney case. So as Emma's saying, it's really, menopause is something that employers are really having to consider now, and they're really having to address for the first time. And we're seeing that in the news, in these cases, and in our own organisations. So here, Ms. Rooney argued that her severe menopause symptoms should be considered as a disability under the Equality Act. And essentially, she gave a lot of evidence as to these symptoms. So it was things such as lightheadedness, insomnia, memory loss, migraines, hot flushes, and the crux of it that she said is that all of these symptoms were having a significant effect on the quality of her life. And it was things like, she went into further detail. So she said that these symptoms meant that she'd forgotten to attend events, and she had forgotten to lock the house and lock the car when she'd left it, and things such as that. And she spent prolonged periods where she was in bed due to fatigue and exhaustion. So very serious symptoms and things that you'd think, yes, they do affect the quality of life, as you said. But despite this, the claims were struck out at a preliminary hearing. So the tribunal found that symptoms were not a disability. And as some of us may know, how it's defined by the Equality Act is that the disability, the symptoms have to be long-standing and more than minimal. So here they said that it was neither long-standing and they didn't have the adverse effect to carry out normal day-to-day activities. But yes, that was the tribunal. So there we go.
No, really, really interesting there, and interesting from the point of view of disability discrimination more generally, is that ordinarily you would have a sort of a preliminary hearing where you would hear medical evidence, you'd hear from the claimant, really to decide if they do suffer from a disability as defined as Meg's defined there under the Equality Act, and it's your ability to carry out your normal day-to-day activities, and that doesn't include your job in many respects. But here the Employment Tribunal found that the symptoms, even though they lasted for more than 2 years, in other cases symptoms can last for many years, as we heard from Dee, that they didn't fall within that definition. The case, really interesting, has gone to the Employment Appeal Tribunal, and why that's interesting is because that decision is now binding on other tribunals. So previously we've had cases coming through the system which have cited menopause, but they have been Employment Tribunal decisions which don't then bind other courts. But the Employment Appeal Tribunal said no, rather than focusing on the things that this individual could do, actually what the tribunal should have done is focused on those things that this individual cannot do, and then conclude whether that those things do have that ability, that impact on your ability to carry out those normal day-to-day activities. So an important case there in the development of protecting individuals who suffer from symptoms with regards to the menopause, but also an important case there when we think about disability discrimination as well. So focusing on the can'ts rather than the things that an individual can do. So some really important developments there. But not just in the courts, Meg, we've also seen the menopause as well. We saw it in Parliament with a private members bill seeking to get HRT treatment free for those individuals who need it. But also we've seen other discussions as well, haven't we? And one of these is with the Women and Equalities Committee. So what's been going on there?
Yes, quite right. So they've launched an inquiry into the nature and extent of discrimination that menopausal women face at work, and especially to consider whether the current practices in the workplace are effective and whether the legislation is effective. And if not, whether that needs to be amended or needs additional legislation. So this inquiry is now closed and the findings are awaited. But what will be really interesting and what we can look to expect, well, hopefully and realistically, we'll get some further guidance at the very least. However, there's also a possibility that a recommendation might be made for the menopause to be added as a standalone protected characteristic, so much like pregnancy and maternity already are. And as Miss Rooney was claiming herself.
So I think, watch this space, but certainly go back, have a look at our webinar, think about how we can support individuals within the workplace, really to make our workplaces more inclusive, for all individuals. So, do go and have a look at that webinar. Thanks, Meg, that is really helpful. So I'm just going to have a look at some of the questions, but before we have a look at some of the questions, just conscious of time as well. As you know, we try and run our webinars monthly. Next month, I'm going to be running a session with Chris Harbour, our head of business immigration within the team. And Chris and I are going to be having a little trip back down memory lane for 2021 and just have a look at some of those issues, not just legal, but sort of, in that wider sphere of people management, people development, and obviously having a look at some of those immigration issues, so those key immigration issues that we need to be focusing on. So an opportunity there to, you know, again, stay ahead of the curve before we move into 2022. We have had some questions, so thank you very much for that. Firstly, we've got just sort of a bit of an observation, and absolutely, I totally agree. When we're thinking about status, so worker, self-employed, or employee, of course, you know, the cases that we've mentioned today are very much focusing on that, you know, are you a worker, are you an employee, are you a self-employed? There are many areas where that perhaps doesn't matter, and one of those is obviously with regards to health and safety. So regardless of whether an individual is an employee, worker, or a contractor, there are obligations there under the health and safety legislation, Health and Safety at Work Act, to obviously ensure that we're protecting all of our people, our visitors, our customers, etc. So thank you for that, that clarification there. And also just a point there about, you know, what happens when you are engaging certain individuals that have that personal expertise. And I think, you know, what we're really looking there is, you know, where is the risk? And, you know, what these cases are saying is you have to look at the facts of each case in detail. It's a question of fact and degree. And certainly, you know, where you've got an individual who is doing a job for a long time. So, you know, we're talking, you know, 18 months. Obviously, once we hit 2 years, you run that risk of unfair dismissal. So, you know, if you've got somebody who's performing a short ad hoc piece of work, you know, and provided you maintain that sort of distance and that commerciality in that relationship, certainly the longer that you have a relationship for, you know, you're giving people business cards, you're giving people email addresses, you're giving them equipment, you're giving them, you know, Pimlico plumbers, vans, uniforms, etc., tools, etc. You know, the greater that integration within an organisation. So status, lots of issues there to think about. And also just looking at the questions there, Meg, and again, you know, I think it sort of probably leads back to what I just said. You know, we were talking about, or we've had some questions here about, you know, what do we mean by in connection with employment? And I'm just wondering if there's anything more we can sort of add there about what that might mean.
Well, I think really importantly, the case which we spoke about with Augustine did ask a few more questions than it answered, in terms of not actually defining how wide that might be in terms of in connection with. It potentially has very wide significance and can include any employer, any cost incurred by the worker. It doesn't necessarily need to be at a reasonable amount. Can we put limits on it? It's left a lot of questions open and unanswered. So to the extent that we can really, really be able to, you know exactly what is incurred and what does need to be taken into account for deductions, which is already a very complicated area, I feel more has been added perhaps by this case than answered.
I think it really goes back to that point about, you know, it's a question, isn't it, of fact in every case. But again, knowing what you're deducting, knowing, you know, what you are really, you know, taking away from people's wages is going to be the same. So, yeah, brilliant. Thank you. Some great comments coming through as well. It's always much appreciated. So thank you so much for those comments that are coming through on the chat. Sharon, thank you for your question. I'll come back to you separately. So thank you for that. Brilliant. Well, thank you so much. Thank you again, as I said, for those comments. That's brilliant. So it's been absolutely fantastic. Thank you, Meg, so much for joining me today. I look forward to catching up with you all at our December webinar, and also watch this space. We've got some fantastic HR workshop and manager training sessions coming up in 2022, as well as our webinar program. So do keep you know, getting our invites and checking out our website. But for today, thank you very much, and thank you to Meg.
Thank you, Emma. It's been really, really enjoyable. So thank you. And I hope everyone took something away today.
Absolutely brilliant. No, thank you very much. And yeah, as ever, we're here for any questions. So do please get in touch. Many thanks, and I will see you all next month. Thank you. Bye-bye.